I'm Dr. Prabha. I'm a reader in law and social justice at the Dixon Poon School of Law here at King's College London, and I'm a co-editor of Beyond Trafficking and Slavery, which is a partnership between Open Democracy and academics from Africa, Asia, America, Australia, and Europe working on the question of trafficking. At BTS, we're keen to challenge the empty sensationalism of mainstream media accounts of exploitation and domination and some rather hollow technocratic policy responses promoted by politicians and businesses. At BTS, we also believe, however, that we need to go beyond critique and ask what's next. In other words, how do we translate our critical voice into one that also engages with the law and policymakers, but also other stakeholders in a meaningful way? So with that in mind, we are here to discuss today the Modern Slavery Act of 2015, which was passed by the British Parliament in March 2015 with a view to eradicating modern slavery in the UK. And joining me today to discuss the Act is Caroline Robinson, who's Policy Director and co-founder of Focus on Labour Exploitation. Caroline, welcome to King's.
Thank you.
So what is the mandate of Flex? What aspect of exploitation are you looking at?
So Flex was established in 2013 to look at labour exploitation generally, to develop a clear understanding, as we saw it as an organisation, of the overlap between many of those labour rights that we found to be abused and the trafficking framework, so the obligations that we could find in the Human Trafficking Protocol, the UN Human Trafficking Protocol, and the various commitments made by governments in international labour standards and the International Labour Organisation, and also the related commitments in things like the European Trafficking Directive and the European Convention on Trafficking. Mm-hmm. And so our mandate is twofold. So we should link our work to international legal principles that we think mesh together to make the whole in terms of a response to labour exploitation, but also we seek to bridge those distinct, sometimes in the NGO sector anyway, distinct fields of activity with the anti-trafficking response, so those that we know are working on migrant rights issues and on labour rights issues, and to look at human rights more broadly, with responses to trafficking, to critique those responses and to engage in a way that we think is productive to a certain degree to try and make those responses better, and to essentially to hold governments to account for the commitments to which they've signed up, that they often try to bend and twist in many fields, not just trafficking, to fit their national aims.
Mm-hmm. So I guess as an organisation that's committed to addressing labour exploitation, I guess the biggest question, or rather the elephant in the room, is what is exploitation? And it's a concept that is not often defined, or not even finds mention in much domestic law, let alone international law. So I'm just curious about what is your political understanding of exploitation and your legal sense of the term?
Our legal sense, we take the understanding from the Delphi indicators developed for the ILO. So we link to the forced labour indicators that they have linked to trafficking for labour exploitation and forced labour. In political and implementation terms, we talk about the accumulation or the combination of abuses, and so else the government turns a blind eye to non-payment of national minimum wage alongside the retention of identity documents, or the excessive working hours and the non-permission of holiday to combine to create a situation of exploitation. I think it's difficult without a definition. I think those indicators help to say that there are combinations that make a situation exploitation, so I suppose we try to stick to those, given that they were created with a consensus of experts, or with a broad range of experts input. And others would maybe link to the UNODC indicators, trafficking for labour exploitation. I find them quite long, but yeah.
So I guess a lot of commentators would actually worry about the ILO forced
Right.
labour indicators, or even the definition of forced labour under the ILO Convention, as being somewhat not minimalist, but falling short of what we might want to define exploitation in terms of. So, what's your sense as an organisation in adopting these indicators, which are for sort of identification of those who are trafficked?
Sense in linking them to exploitation is to tie to the offences that governments adopt in relation to trafficking and forced labour. At the same time, Flex seeks to address abuses that are not thought to constitute severe exploitation, and we do that within the framework of prevention, and we say that there is a strong need for governments to address labour abuses on their own in order to prevent that accumulated combination of abuses that we think equates to indicators of forced labour or trafficking for labour exploitation. I think it is we've always, I know at CATW there were many conversations about the problematic focus on the tip of the iceberg without any focus on the other massive part of the iceberg, or the pyramid with the huge base that no one cares about, and then the very top, which people spend lots of international attention looking at. But we've tried, and that this we did through the modern slavery bill negotiations a lot, to talk about the need to address those broad and pervasive labour abuses in order to prevent the clear gaps emerging in labour protections and the labour regulation framework that would permit severe abuses or severe exploitation, where those abuses build up and employers get away with more and more because they can, and that becomes more and more exploitative.
That's an excellent image of the pyramid. One might also think of a continuum of exploitation. Yeah. So in the context of the Modern Slavery Act, I suppose, being a criminal law targeted the tip of the iceberg, as you rightly pointed out, and you read Payne's, it seems to draw attention to the structural conditions that then lead to this kind of extreme exploitation. So if we look at Section 3 of the Modern Slavery Act, we have some attempted definition of exploitation, and it's a rather long section. What is your sense of how it defines exploitation? Would that meet your concerns?
We just struggled during the immigration bill negotiations, actually, because the role of the director that's been established in the immigration bill is tied to protecting workers that are victims of offences under Section 1 of the Modern Slavery Act, and then under Section 2 only workers that are documented are protected. and the idea apparently behind this was that there was a kind of, because labour exploitation, the government feels they've tied to Section 1, so forced labour, slavery and servitude, they don't need to add in very much more with relation to the Director of Labour Market Enforcement, who's supposed to look at cases of labour exploitation. The reason I mentioned that is what became clear to us then is that that labour exploitation has been very much lumped into Section 1 of the Modern Slavery Act, so forced labour, slavery and servitude. So the attempt to kind of understand what trafficking for labour exploitation means in this government's strange separations of offences, which we don't agree with in the Modern Slavery Act, as it's kind of a narrow definition of trafficking as about travel and transfer of people across borders largely. That attempt to define or to set out exploitation hasn't been made, and I think the government is very wary of making any attempt to understand what labour exploitation means and to set out. And I think they've said, I guess similar to the ILO, they've said they would potentially set out a series of indicators to understand what that means, and that's but that's not. I mean, that's kind of done in the National Referral Mechanism referral forms, but as you said in the bill, it's a long section, but it refers back to Section 1 for labour exploitations. There's not a clear in the Act. Sorry, on slavery.
So I guess Section 1 refers us back to the European Convention on Human Rights. So is that
Mm.
so? And clearly, there, if one looks at the case law, the interpretation of what slavery is and what servitude is has shifted over time. So is that something that's attractive to you in terms of the reference back to EU law, which has generally been somewhat more, somewhat broader than other attempts to understand slavery under international law, for instance?
Yeah, I think it's useful to have the reference to the European Convention of Human Rights. The work that we've done subsequent to the Modern Slavery Act is to look at gaps and opportunities to pursue strategic litigation in reference to the UK's obligations. So I think it's useful to have that in the Act as their understanding of their obligation, so that we can show where they're not meeting that. And particularly in relation to prevention and identification, which where we then can tie to cases the European Court and the case law that such as Ransev, where we have clear obligations on states to set out in judgments where they have failed to take steps to prevent exploitation from occurring.
Mm-hmm. So, just switching gears, we're very interested at BTS in what kinds of opportunities are available to NGOs and civil society actors in general when legislations are proposed by politicians who are carried away by the rhetoric of, ending slavery and everything that goes with it. So, tell us a little bit about the involvement of Flex in the various steps leading up to the law.
I think we were quite, I suppose, as opposed to this immigration bill and perhaps other areas, we were quite similar to other anti-trafficking organisations in terms of our engagement. I think there was a more clear than I would say in other section areas of legislation. The current government, I suppose that's the previous coalition government then, to engage. So the modern slavery bill process had a pre-legislative inquiry chaired by Frank Field MP. It had a select committee established to debate the bill, the draft bill, and then it had the committee stages in the House of Commons and the House of Lords. So it had a few kind of quite clear formal processes of engagement, which meant that which meant that there was opportunity for Flex and other anti-trafficking organisations, many of whom did take advantage of that, to engage quite heavily throughout the process. So I would say that there was much better formal channels of engagement than there are, for example, with this immigration bill, which hasn't had any pre-legislative scrutiny at all. so it had stages in that regard. With the Frank Field pre-legislative inquiry was a strange process because it was unclear how it tied to the government's bill development process, and I think that came out quite clearly when Frank Field published his report and the minister published her draft bill on the same day, I think, or a day later. I'm trying to remember now how it worked, but I remember he was quite frustrated that actually, I think he seemed to have been under the understanding that his report would feed into the development of the bill, and actually it was kind of welcomed and fed into the then pre-legislative scrutiny of the bill, which it was fine, I suppose. But so we engaged in each of those processes.
Mm-hmm. So given this sort of backdrop where you have two parallel processes, that one is ostensibly supposed to be feeding into the other, but actually not happening, what kinds of political opportunities did groups like Flex see? And, did you feel like there were other informal venues through which you could influence policymakers?
We engaged. There were opportunities because there was quite a long lead-in to engage with members of Parliament from an early stage, which we did. Opportunities to publish and share responses to the various consultations which we did, and we had this. There's still the opportunity that there has been. There's a Home Office kind of modern slavery stakeholder forum and various associated groups where the Home Office kind of takes information and reviews it and seems to show an interest in what NGOs have to, or sets out to show an interest in what NGOs have to say.
So after this sort of elaborate process of consultation, were you happy with the resultant act?
The areas that we worked most strongly on were related to civil remedies for victims of trafficking and on the strengthening and the extra resourcing of the labour inspection authorities, and on transparency in corporate operations and accountability for labour exploitation in supply chains. So I would speak in the and one area that we worked with the Home Office, I would say most closely on, is the offences and the way they were set out. So on those 4 areas, I suppose, we had different degrees of happiness. The first, which was the offences, we had tried to set out the scenarios where we found that cases of trafficking would not fall within the trafficking definition, and that we felt within international law would fall within trafficking, and that the narrowing of trafficking to travel was problematic in terms of holding the government to international obligations towards victims of trafficking. Normative and legal text included that where we felt there were strong obligations to protect, and that whereas the government was satisfied that the Section 1 and Section 2 offences covered the whole set of possibilities of exploitation within trafficking, forced labour, slavery and servitude, we argued at the time and felt that it was important that trafficking reflect the broader acts that could take place within the UN Human Trafficking Protocol definition, including harbouring, where travel and recruitment or the movement of people was not required, whereas the government was keen to limit it to the movement of people. We also felt that it would be confusing in practice to have that as the distinction between those 2 offences, and it seems in developing the related policy that it is quite confusing to have implementation-wise to tell people that it is the difference between those 2 offences is the travel of someone, because that's not actually the case in terms of the international legal framework. So that was the one thing that we worked with the Home Office on in terms of sharing scenarios and trying to argue for the broadening of that definition, on which we weren't successful. But we had some success, and I'm struggling to remember it, in relation to the Section 1 offence, and there has been the broadening of the national referral mechanism support for all victims of modern slavery in England and Wales, whereas in Scotland actually it's still just for victims of trafficking, which now is problematic because in Scotland they have to take on these offences. So victims of trafficking in Scotland are just those who have been travelled into that situation. And the other, thank you. Just looking to see, I can't remember what the amendment was in the end, whether we actually had. So I'm not quite sure whether we had much success in that regard. I'll say we didn't, given that I can't quite remember what the success was. On the civil penalties, there was very limited. So an amendment was tabled at report stage in the House of Commons by one of our trustees, Paul Blomfield MP, on civil remedies, for victims of trafficking, where it was drawing on a discussion that we'd had on the development of a legal guide for victims of trafficking, where various remedies were evaluated through focus groups that we conducted on the ground with people, and it was felt that in terms of civil remedies, it's very hard to take a case without having a clear civil remedy relating to trafficking. The amendment was to try and establish a remedy route that would link to trafficking particularly. And that was taken up again. We then had a meeting in the Lords on access to justice specifically, and we looked at civil remedies and legal aid, and how legal aid is not available until you consent to enter the national referral mechanism, at which point you've not been given legal advice about entering. So we talked about bringing those issues into the Modern Slavery Act and ensuring that people had a clear civil remedy and that there was legal aid from the point of contact with a service provider, so that there was an ability to use legal advice to ensure to advise on the entry into the national referral mechanism. But the take-up of the legal aid was just prior to the general election, and questions on money in general were very difficult to get to, and legal aid was seen as a kind of no-go area in that regard. And the civil remedies, the Ministry of Justice responded with a letter to peers. So following our meeting in the House of Lords, Baroness Young tabled an amendment, which I think Perosha assisted her with, that related to civil remedies and kind of broadened the amendment from we'd had in the House of Commons. And the response that came from the Ministry of Justice was that we have this existing remedy framework and there are adequate remedies and there's no need for further remedies to be included in the Modern Slavery Act. And they're always of the view that you shouldn't add remedies for the sake of adding remedies, and they have this existing. But we never found... We've then asked many questions about what evidence they had of this and how, and the problem that we've had with any questions relating to remedies and compensation, particularly for victims of trafficking, is that this government doesn't collect any data on that. And so when the government says the remedies are adequate, we have no idea whether that means one person received one last year or 100, because no data is collected. Anecdotally, we know how difficult it is for people to receive compensation and to access the various remedies, and particularly victims of labour exploitation, to access the government's official remedy channel, the Criminal Injuries Compensation Authority. And so we wanted to try and broaden the routes for people to access them. So I would say that was unsuccessful. That was I think the discussion didn't get very far. The transparency in supply chains work that we did was in coalition with a number of organisations. There's a huge interest in that area of the bill, and it was something that Frank Field and the Centre for Social Justice, which I suppose was kind of a pre-legislative document in the Centre for Social Justice, produced their Modern Slavery report in 2013, which coined the term modern slavery and suggested a unified act in the UK, and I think the government has suggested, Theresa May suggested, that part of the impetus for the Modern Slavery Bill came from that piece of work. And so that, I believe it was the Centre for Social Justice, but definitely in relation to the Frank Field inquiry, that this idea of some transparency in supply chains clause or amendment that linked to the work that Michael Connaughty MP had done in that regard was worked on for the Modern Slavery Bill. And I think there was a commitment made early on that the Home Office were interested in this, but they felt there was a resistance from other sections of the government to do so, and so that if there was pressure from civil society, then they might have the case to bring this clause forward. So that the amendment to the Modern Slavery Bill that brought in the Section 54 clause so Section 54 of the Modern Slavery Act was brought, I think it has a Commons report stage, by the government, and partially amended in the Lords based on the cases made by Lord Alton, largely, who was working very closely with our kind of broad coalition of organisations that were working to get a strong amendment on transparency in the Act. So I suppose that has been the most successful, thinking about it now, of all of those measures, because the government acted to put something in the Modern Slavery Act. The question about the utility of that amendment remains, but I'm finding it actually quite useful at the moment to use in advocacy. So I suppose it has its uses. We wanted it initially. The amendment that we had suggested for the Modern Slavery Bill was much more prescriptive in the activities that governments would have to undertake and the obligations upon companies within that Act. And interestingly, and I don't know if you've seen it, we've only just noticed, we didn't engage in advocacy on the Scottish Human Trafficking Act, but there are clauses in that Act and in the Northern Irish Trafficking Act that are actually much stronger in relation to corporate liability for activities overseas in relation to trafficking offences. And we don't really know how they occurred, because we've talked to NGO colleagues in Scotland, and we talked to the Scottish Government about why that clause was put into the Act, which came just after the Modern Slavery Act, enacted in September this year. And there doesn't seem to have been much of a drive, so it's almost as if it happened by chance, but it's much more powerful in terms of the potential to hold companies criminally liable for activities overseas, whereas as you know, with this amendment, we can't hold. I mean, you can fulfil the terms of the amendment by publishing a statement annually to say you've done nothing to address exploitation. So there's not the strongest in terms of actually holding companies liable for abuses. And then Section 55 of the Modern Slavery Act, which looks at the Gang Masters Licensing Authority and reviewing its role. And that was something that we had called, that was one of the main areas that Flex worked on during the passage of the Modern Slavery Bill, was to resource and extend the Gang Masters Licensing Authority, which we felt there was an opportunity in the Modern Slavery Act to broaden its scope to the sectors where people were telling us that they wanted oversight. And we were very wary of how that would work because of the very limited resources upon which it operates. So we wanted to see any expanded remit associated with expanded resources, and also for its expanded remit to look as its current remit looks, so to focus on the licensing and monitoring of labour standards, or licensing standards which tie to forced labour indicators, and for it to do that in other sectors. And the government resisted amendments to the Modern Slavery Bill that looked at the Gang Masters Licensing Authority remit specifically, but they, as on issues like domestic workers, suggested that a review or a report would be the best way forward. And so a review was promised within a year of enactment of the Modern Slavery Act, and that was Section 55 of the Act. And so whether we're happy with that was, I think, one of the things that I thought was progressive along that journey, because we made that argument in the context of this, as I said earlier, this kind of broader labour abuses and the need to ensure monitoring across the labour market, and discussions about how weakly regulated the UK labour market is, and the need to have, because we have no overarching labour inspection body, to have a body that was monitoring compliance with labour standards for and in the context of the Modern Slavery Act, for the purposes of preventing exploitation and abuse from taking place. And in that, the context, and in those debates that took place at the various stages of the Modern Slavery Bill on that lines, in the House of Lords, the debate turned to labour inspection agencies in general and their role and how they're resourced and the massive cuts that they face to their resources. And I would say one of the I think one of the biggest wins we had, which is not a very big win, was the reversal of the cuts to the Employment Agency Standards Inspectorate, for example, in a letter from the Minister during the House of Lords debate. So it had been raised that the Employment Agency Standards Inspectorate had been reduced to a staff of 3 and a budget of they wouldn't disclose the budget at the time, actually, but we imagined with a staff of 3, not very much. And the promise in the letter was to redouble the staffing and redouble the resources, including extra staffing. And we know from this year's statements from the Employment Agency Standards Inspectorate that at least they have returned to their pre-2013 cut. So they've gone back to a staffing of 9 and they have a budget of 500,000, which is kind of just below what they had in 2013, 2012. So it's not a very big win, but it was a recognition of this link which we wanted to see the government make, and we need to remind them of now quite regularly, that there is a link between labour inspection and regulations, which they don't like very much, and modern slavery, which they suggested they had a big focus on and a drive to address. So that was one thing, and the GLA review was always a worrying one because we didn't really know what that meant, and we got various commitments through questions via members of the House of Lords and the Commons at consideration of amendment stage on to make sure that wouldn't mean a reduction in the GLA, and that it wouldn't mean a questioning of the licensing function and the core function of the Gangmasters Licensing Authority. And in the House of Lords, that question was put, and we never had a firm answer, which is now clear in the consultation that the government has launched on the Gangmasters Licensing Authority, which suggests a flexible approach to licensing. So that review was a difficult one for us because it wasn't guaranteed at that stage, and I think we're seeing that the review would be used potentially to reform the GLA and to shift it towards a different agenda.
So this is really absolutely fascinating. But we often tend to think that it's in fact very difficult to make the kind of argument which you're making towards a more structural response to questions of trafficking and slavery and exploitation. But were you surprised by how the government was willing to make the link? Was it clear to you that, were you surprised by how, not easy, but how, there were openings for making this argument and for the government to actually make the link in the argument that you were putting forth?
Yeah, I think that, it was the minister that used the term spectrum of labour abuses, spectrum of labour exploitation, and linked the work of the Employment Agency Standards Inspectorate with the work of the National Crime Agency on different ends of the spectrum. And we felt that was at least, and she made that, we had a meeting with her actually separate during the passage of the Modern Slavery Bill between Flex and her, and she made a similar point and suggested that they need to get right the roles of different agencies so that there's not overlap and competition between agencies, and that that we address each part of the spectrum, which we thought was positive at the time. And I think there were members of the House of Lords that were quite clear on that link, and people like the Bishop of Derby, who tabled separate to, I wouldn't claim much engagement with the Bishop of Derby, separate to much advocacy. The amendments that kind of linked labour inspectorates to the need to prevent exploitation and kind of talked about that link. And again, people like Baroness Hamway wanted to table an amendment on exploitation, which we thought was slightly problematic because it was suggesting there was a kind of lower form of exploitation from the exploitation in the again, this kind of tiered approach. So we have abuses, some lesser form of exploitation, a severe form of exploitation. But I think with her amendment, she wanted to tease out what would happen in cases that don't qualify for these offences. What do we do about them? And I think that's a really valid point, because we're finding that, and that's something we're raising a lot during the immigration bill debate, is that those offences increasingly, I mean, labour abuses increasingly have very few avenues for justice, and there's very few means of even raising labour abuses, let alone accessing remedies for those abuses. And so, and increasingly with shifting employment statuses, increasingly things that would previously have been abuse under employment contracts are no longer actually an abuse. It's just a free-flowing employment, like a 0 hours contract or self-employment, where there's very little to hold anyone to in terms of protection. So I think it was good to have the Lords make that link particularly well, I would say.
Mm-hmm. And so you mentioned the Bishop of Derby, and clearly there were some unexpected allies in this whole process. Were there other allies who you wouldn't have factored into your efforts, but who were listening to the kinds of arguments that you were making?
I would say that Sir John Randall in the House of Commons was quite active, given that I think because he was stepping down at the election, and I'm not sure, as a Conservative kind of former government whip, like I felt that he took more of an interest in victim protections than perhaps, that took a more dissenting line than might have been thought. I was quite wary of engaging with him because I wasn't positive of his agenda because of his proximity to the government, but I did appreciate some of his remarks and thought that he sometimes took an interesting line on the bill. Trying to think back now. I suppose it was good that Baroness Hannam and Baroness Hamway voted against the party line on the overseas domestic worker amendment in the House of Lords. That was a brilliant success for organisations like Justice for Domestic Workers and Calayan in terms of getting that on the record in the Lords. And I remember contacting Baroness Hamway afterwards and saying it was well done and it was a really good move. And she said, we shouldn't celebrate now because it would probably be overturned. But I felt it was, and I said, I think it's important to celebrate because this is the House of Lords recognising that domestic workers are being exploited under current visa regulations, and we need to celebrate those wins despite the fact that we're about to do nothing about that.
Yeah. Absolutely. It's actually a far more complicated history than just wins and losses. So it's still early days, obviously, with the Act, but do you have a sense of how it's being operationalised?
A little bit. We have the it is being operationalised in relation to the so elements of the Act have come into force, and we have, the most recent being the Transparency in Supply Chains guidance is there, so the Section 54 guidance, and companies are preparing to disclose in whatever way they choose, and we have this duty to notify, which is definitely being implemented. It has been implemented in advance of it coming into force. I think that came in July. in Wales in a pilot. I think there are some thoughts on that and how it's quite hard to do that whilst retaining anonymity and whilst ensuring that people are happy to consent to the national referral mechanism, or to engage at all if that means that their information, whether anonymised, will be passed on to the authorities. We have the review of the Gangmasters Licensing Authority, which is within the terms of a consultation on tackling exploitation in the labour market, which was published by the Department for Business Innovation and Skills and the Home Office, and closes on Monday, I think, the 7th, if that's Monday, of December. And I was mentioning before things like the associated code for enforcement officers to associate with things like the maritime powers have been produced, and will then, I suppose, be rolled out not within the Act, but promised alongside the Act is the review of the national referral mechanism and pilots to review, to help with that review, or to implement some of the findings of the review that was published in 2014, I think. 2014 have been started, and so sorry to say what the sense is of those measures. There's a kind of early stage sense, I suppose, and the things like the review, the national referral mechanism pilots. I'm meant to be a panelist for decision making panels in the national referral mechanism pilots, but I haven't yet sat on a panel, so I don't know how they operate. We've engaged a lot with the guidance for that process, because we felt, as I was saying, that the offences, it was quite hard to define what they meant by the different offences because of a distinction in the Act. So that's been tricky. And the transparency and supply chain, the Section 54 elements, I think companies are saying at least that they are very worried about them and they're gearing up to respond. So I suppose there's that. And the review of the Gangmasters Licensing Authority I mentioned, we find, I suppose that's the element that we find most problematic, but that's the part that we're most engaged in, is because there's a threat to the Gangmasters Licensing Authority's licensing functions and to its work in the round, because there's a proposal to extend it across the labour market, which I suppose we would have supported, but with no extra resources, so we don't support it as a suggestion. And for it to have increased criminal powers, which it argues it needs, but we worry about the cost of moving into criminalisation or criminal investigations, and losing the focus on the enforcement of its licensing standards, or the monitoring of its licensing standards, largely.
So again, taking off from your comment just now, what is your sense of the likely consequences of the enforcement of the Modern Slavery Act? Because often, those of us who work in criminal law are quite painfully aware of the symbolic function of criminal law. In a certain sense, you actually don't need special legislation to prosecute trafficking. A prosecutor could come up with a whole range of offences they could prosecute someone for. And so, given the rather dismal rates of conviction under the offences which preceded the Modern Slavery Act, what is your sense of how it might be enforced going forward? Do you think it'll make a big difference? Do you think the numbers will continue to remain small? Or will it shift the way stakeholders are viewing labour markets in some way, just because we have the Act now?
Yeah, it's hard to... it's hard to say what... I think it will be hard for the government to not come forward with an increase in prosecutions, because that's the main thing they wanted to see with this act. So I have a sense, with no evidence, that that will be the focus on the ground, is to try and find cases that will get a prosecution, and to really focus resources and attention into those cases, because they need prosecutions to justify the extra focus and to suggest that they've made progress in this area. In discussions we've had with kind of people like frontline police, they've not seen, I mean, there's not been much increased awareness of cases of identification, which has always been a problem, is that kind of people come forward and they're not identified because there's a limited awareness of what constitutes trafficking and trafficking for labour exploitation. But also there's been cuts to resources, and resources has always been the big problem because investigations cost so much money, and we know for particular specialist units that they've seen big cuts, so we don't know how that will tally with an increase in investigations and prosecutions. From service providers that we work with, or from those that aren't traditional anti-trafficking organisations, migrant community organisations, and actually, but then trafficking organisations are saying this as well, they've seen an increase in referrals of cases, and they don't know why. And one reason could be to attribute the big push that there's been around modern slavery, and the government spent, I think in the end, 2 million on the publicity campaign on awareness of modern slavery, which they maybe could attribute that to. But so perhaps if there's an increased referrals, but I don't know what I mean, that's from people saying that. I haven't seen the referral data, and I don't think it backs up a heavy increase in referrals. I'm not sure how they'll. I mean, I think there's always kind of political will to get for the main thing you want to. If you want to achieve prosecutions, I suppose there'll be a focus in that area to try and get prosecutions.
Mm-hmm. And so I guess there were many aspects of the Act which, Flex lobbied for or against, and many of them are subject to review going forward. I'm just curious about what's the sort of strategic vision for Flex now? Is there a sense that there might be possibilities for future amendments, or should one work more at the level of institutional reform? Are there beneficial models in other countries that one might look to? Certainly on the supply chain transparency question, the US and Brazil, and clearly there seem to be even models within the UK on how to go beyond what Section 54 has. So what's your sort of short-term and long-term strategy at Flex on this question?
So short-term, we're very much focused on the partial outcomes of the modern slavery agenda, I suppose, in relation to the immigration bill that the government's proposed, and the consultation on tackling exploitation in the labour market, and and addressing the premise of those pieces of that policy and legislation that sees exploitation as as distinct from general labour market compliance, and trying to re-engage those who during the modern slavery bill saw a link, and to talk about the need to address worker vulnerability in that link. So we're working a lot on that in the short term, and long term I think we are doing that comparator. We've established this database of legislation to address labour exploitation in company supply chains, that currently looks at 10 countries, and we're expanding it to another 5, I think. And it includes countries like Brazil and Belgium, where there are good case studies, and the USA. There are good case studies, and where companies have been held to account effectively under legislation, and looks to mechanisms that could be used in different countries to gain remedies and to hold companies to account for abuses. And so that will be good to use. I think we want to continue to explore the potential for labour inspection to prevent abuses, and to look at other strategies and mechanisms for workers gaining access to advice and remedies prior to exploitation taking place, so to prevent as a preventative tool, and to continue to argue for the delinking of immigration control from responses to exploitation, and that's just very pronounced in the current context of this immigration bill debate, where we have which came from a framework set by the Prime Minister on the 21st of May, that we need to both address the exploitation of workers and the undercutting of British workers by migrant workers, and that we could do the two together and achieve a kind of grand response. And in the consultation document I mentioned, where this distinction is created between labour market non-compliance, which the government says is now not a big problem, and what the government terms organised labour market exploitation, which is where the focus should be. And it comes back to your question of what labour exploitation is, because we really don't know what organised labour market exploitation means, but we have a hunch that it relates to immigration offences, and that it definitely doesn't link back to any structures that are faulty in the UK labour market, and so it doesn't question the terms of the current operation of the labour market, and why people are facing abuses, and why those abuses might develop into severe exploitation within the formal within our labour market. And so I think those would be the areas that we're trying to link to.
So what's your sort of sense of this paradigm of modern slavery or trafficking or forced labour? Because these are clearly issues that have some vintage, the question of migration, the question of labour exploitation and so on. And some observers, possibly academics who have the luxury of observing, might actually argue that the modern slavery paradigm is very seductive, but really at the end of the day gives us very little and actually does more harm than good. But clearly as an activist on the ground, you might have a different view of this paradigm. Could one simply say, let's reject this paradigm, because it is based very much on hyper-criminalization model, and then that seeps onto the immigration agenda? Or do you think, for organizations such as yourself, labour exploitation would not be on the table were it not for this rhetoric and focus on modern slavery?
I think we're definitely operating in the context of a decreased focus on labour abuses, regardless of modern slavery interest. And so things like, when we were just talking about them this morning, actually, things like the employment tribunal fees, the axing of the Pay and Work Rights Helpline in the UK, merging into ACAS so that there's a kind of limited resource to address labour abuses, and the cases that we're seeing where people just don't have any way to get redress for abuses, and a context in which there are very few safety nets for people outside of the UK, but probably increasingly inside. Kind of British nationals or European Economic Area nationals, and particularly for EEA nationals, to have any kind of safety net if anything happens in the labour market. And so almost necessitating vulnerable employment because there's nothing else. And we see that a lot. And this kind of, I think this is something that doesn't really relate to the modern slavery crusade, if you like, because it's a definite drive of the government. And in 2011 they launched the red tape cutting agenda, which was all about getting rid of regulations and freeing up the labour market to promote growth. And it's happened in other countries, and we talked about India and how this is happening there too, and it's a need to see and a kind of global focus on labour market flexibility as a means of promoting growth. And so I think there's that, and it's very hard to... We've found, and working with unions more and more, we've found it's hard to push back on those terms, because those are now the kind of new paradigm, the new accepted debate, and so whilst I take, and I have heard many years of criticisms of the modern slavery framework, and I agree with many of them, I think that it provides an opportunity to question those terms in a way that I'm not finding I'm looking for them in other forums, other ways of questioning those terms. And I think that with the strong commitments that governments tend to make and like to make to address slavery, and the drive to save people from being victims of this centuries-old crime, and this kind of, I don't know, the kind of, as you said, the seduction of this discourse is a useful tool to tie those concerns to in certain, and we need to use it very cautiously, and to be aware of the possible negative repercussions, and to address those as well, and to stay engaged in that debate, and not to kind of blindly advocate things like the expansion of the Gang Licensing Authority, and then not to deal with the consequences of now having a suggestion that it will be expanded but with no extra resources. And so to kind of continue to engage, and to understand that at all stages, if the state has a kind of if the state is pursuing a kind of ideology, then that will be pursued through whatever means, and we have to kind of weave and work around that as advocates. But I do think that this is that it's right for people to care about exploitation, but as we've said before, it's not right for them not to care about anything else, and only when it reaches a kind of certain miraculous point where people can be categorised as victims and criminals can be prosecuted. And so if there's a way that we can kind of draw people into a focus on what this deregulation agenda is doing to workers in terms of protections through that, then I think that's really important. The other area that Flex is keen to look at and hasn't done enough on yet is to kind of understand what narratives of exploitation people are, what understandings of exploitation the public has, and how they perceive acceptable and non-acceptable levels of exploitation and abuses. And I think that feeds into it a lot. So this kind of continuous discussion, the idea that some forms of abuse and exploitation are justified towards certain nationals of certain countries because they face abuses in their own country, and so these are better abuses than those abuses. This is a better low wage than that low wage. And we would like to understand more like that kind of the social understandings of exploitation and how that feeds into what governments are prepared to address, because they are very dominated by these kind of, particularly on immigration, it's so responsive to a kind of fear of public opinion and so there's often quite a limited link between the actual response and what's needed in practice. And I think government's aware of that. Many of the measures in the immigration bill to try and reduce net migration figures, which is kind of what the public pressure is saying needs to be done, won't really do that, because things like the offence of illegal working will push people further underground. So it will ensure that people are undocumented and remain in vulnerable situations, and that there's a kind of way of controlling and coercing them into those vulnerable situations. And similarly with things like the landlord check, like people won't go to reputable, normal, like landlords who are going to check, they'll then like be in kind of more hidden areas. And I just think that there's this drive is related to what looks good on with the public, and we therefore need to understand what that public opinion is saying in relation to exploitation, and why this distinction is kind of considered okay, that certain labour abuses are considered okay, and how. Sorry, I lost the question.
I think that's absolutely wonderful, actually. I guess so. If you were just extricated somehow from all the pressures of day-to-day campaigning and lobbying, and you could just think of sort of 5 strategies, maximum impact that Flex could pursue, to target trafficking, modern slavery, exploitation, whatever it is that Flex is most keen to address. What would those be? I mean, you mentioned strategic litigation earlier. What kinds of hopes do you have that you'd really like to explore more fully if you had the opportunity?
Well, we're piloting a kind of legal advice program that with various partners, where it's about giving people a much broader range of options than just the modern slavery response. And I suppose that would be one thing, is trying to encourage a broad range of advice. It kind of exists in specialist agencies like ATLU, but there's around the country there seems to be quite a narrow understanding of what people can access in terms of support for exploitation. And so to give people a range of options and to try and find ways of people for example, potentially pursuing a compensation claim and getting discretionary leave to remain on the basis of that compensation claim rather than a criminal case. And so that would be one, is to try and have to channel people more broadly than just to go through the support system and go home, or to go through the support system and go into asylum, an asylum waiting system, and then not potentially to get asylum. And then to have a kind of broad, a real a labour inspection system that's really focused on addressing abuses and providing remedies for those abuses, and that looks at workers and workers' rights and the ways in which, particularly in which various employment statuses are being used to reduce liability for those rights, and to kind of set in place various ways of diluting accountability for labour rights. I think we'd like to see. I mean, the strategic litigation thing you mentioned. One of the things we're looking at with Callahan and others is to look at the overseas domestic worker visa in the UK, and to try and challenge that on the grounds of international law, and that. I think, I mean, an ideal for me, like a total utopia, would be to kind of abolish this, which is a big failing of the modern slavery anti-trafficking framework. But it's not. I mean, it's not prescribed in the. I mean, protection is there in the UN Human Trafficking Protocol, but not this kind of real, like, open and shut protection where we have a 45-day period in the UK, and we're looking at other countries in Europe at the moment, and it's similar in terms of you have this kind of reflection and recovery period, which is very limited, and then after that you have to engage in criminal proceedings in order to get anything else, or you have to, as I said, kind of go down the asylum route, or you have to have a serious psychological support need in order to remain, or to continue to reflect and recover, or to recover and not return. And so to get rid of that kind of really time-bound recovery, which actually, interestingly, partners in Romania who have don't have funding from the state to deliver services, but they deliver services to people who have been trafficked, and they have no kind of, they find the idea that you have like a cut-off point to recovery like very odd, and like how you would deal with any other situation if immigration wasn't a factor, where you wait till someone's recovered to push them into destitution, which happens a lot now with the 45 days, because if, as I was saying, if you're an EEA national and you don't have any evidence of work, then you go back with no job seekers allowance and no housing benefits onto the street. So I guess that kind of really cuts to the core of the idea that someone is a victim for a brief period of time, and then they're kind of a reject from society, and until potentially they're re-victimised and they come back through the system again for another 45 days, which is something we're trying to document, because it seems like a massive failing of the response. I think that's 4 things, isn't it?
They're quite significant.
Yeah. And I suppose the 5th thing would just be to have a real overhaul of how, I mean, but it should be hopeful for something, I suppose, to change about the way that that trafficking is used as a tool to justify harsh immigration responses and harsh things like, and it's good to see I think it was Julia O'Connell Davidson, wasn't it, who coordinated the letter about the Mediterranean and the use of trafficking and slavery to justify kind of harsh responses to the boats, and I guess that for me that feeds into a broader, and I think I found that a lot working at GATW, a broader kind of paternalistic use of the trafficking framework, so a desire to use it to justify actions on others' behalves, and to remove agency, and to particularly in relation to women in many countries, and to suggest that there was a response that was required, that was where the state knows better than that individual. And that's at the moment we see it with the immigration response, so the state knows that you the state knows that you shouldn't be migrating because it's dangerous for you, so they want to stop you from migrating. But also with use, the state knows that women shouldn't be doing certain types of work because it's dangerous for women to do that work, so they need to be prevented from working in the sex industry because it's a danger to them. And I think that the paternalism kind of flows into the response in terms of the victim protection, where you get this kind of often quite heavy-handed and very intense protection for 45 days, and then a kind of pushed back out.
That's great. Well, thank you so much, Helen, for sharing your experiences with us.
Thank you.
Thanks. That is fantastic. Thank you.
All right, answer.
So I'm just going to take a
Yeah.
So I think you might be actually stranded after a match. Oh
yes, this is quite good.
Hi, Bhuvan. Oh, good. Okay. Which? Yeah. Okay. Yes, please. Thank you. Yeah, if you want, you can drop off your bag and then go. Okay. Okay. Thanks. Thanks, Bhuvan. Yeah. Bye. Sorry.
How old is he?
He's 12.
Oh.
Yeah. He's, yeah. Last night I went for a teenage, whatever, parent practice. There's this whole professional parenting thing now.
Really?
Where
What's a kind of course on it?
yeah, it was actually my daughter's school, and
Ah.
she's much younger, but they were offering this talk on how to deal with teenagers. And I was like, he's 6 months away from being a teenager, so I should go listen. Yeah. So he's quite he can do a lot of things on his own now, but that comes the issues.
Yeah, I don't like the idea of doing things on their own.
How old